Um,
They're like,
so just real quick, you did include what I requested, right? Is this for the recent request?
When you get stopped, the bond, votes and
The bonds. What about the chatter? None of
I
that.
don't, I'm not gonna be deciding anything else. You have to go through the.
Right. Well, no, I did. I sent them the open records for the chatter and
That was
stuff.
just the one you sent down, because I didn't know what it was about. I thought it might have been one of our cases, but it's a new deal, so.
I got you. I got
I didn't
you.
know at the time, so I just went into it.
I got you.
Yeah.
Yeah, I kind of took over the whole thing.
Yeah, my two older brothers and then my youngest brother was but my brother just gifted me this watch. It's beautiful. And he gave me one. Yeah, he did it. My mom was trying to do it. Anyway, we'll see. Yeah. You're not, I gave you all the money. Whatever you do, I think you enjoy it. I plan on it. I've got 5 beautiful grandkids. My grandparents, they became grandparents, and I don't recognize it anymore. I'm like, this is. I know. And my dad sat down, I said, just about it. And I was like, oh, this is a little bit different. He goes, let me tell you something. Everything he does, the best thing.
Oh, yeah, it's like, you treat like a sheriff. Yeah.
We're gonna bring something home.
Yeah.
And honey, you made that. Yeah, I
Yeah, I printed it out. It's really directed to you, but I wanted you to see that.
I'm getting it all. And she's still out home.
Got look.
Wow.
Morning. Morning.
Everyone because it's here in person, right? That asked about. Good, because I did not get.
It's a beautiful drive. They wanted to come see it. They've been away a while. Yeah, I was gonna say we did.
Yeah, we felt. just joking to them, it's like, I know it's not the prettiest place, like, the liability. Like, if you don't know the city, if it's happening through, but you're gonna, like, some of the nicest people, it's like, no, man, this is a nice people. And so I think, have you been doing that podcast with me? I said, my sister-in-law was in that too. Okay, some rich, some woman married a rich guy. And you know, and then she wrote her, and Mitchell is her name. Julie Mitchell. She was, okay, well, she didn't say, so she, Mitchell, I'm so sorry. I promise I'm professional sometimes, but sometimes. Okay, Amy, her name is Amy Dirickson. Or in New York, and she writes, I think the book called A Tale. Anyway, her freedom said, all this happened. Anyway, so, yeah. Oh my God. That's the kind of stuff I you know, that sustains me, but I guess it's better to bring it. Anyway, I told her all about,
Yeah.
the same view. But it was after. Hello.
Well, that's what you can tell me. Downstairs.
Oh, I didn't know you did that.
There's several motions, but I'm not sure what.
Is the judge in there?
Hey Donna, I'm gonna ask the judge if, right off the bat, we could swear in, so I'm not arguing, if there's any evidence and facts. Is that fair with you?
To swear in what?
Well, I'm just gonna swear in. Like,
Swear you in?
well, you swear me in like you usually do.
Well.
I'm gonna ask him, I'm
Yeah.
gonna ask him, so I'm not argumentative, and I just.
Nothing happened to me ever.
Ricky, how many trials do you end up with?
4.
We're down to 1.
Yeah, I got 4 jury trials, 3 in Custer and 1 in Washington.
Oh, one in Washington.
Yeah. It's a kidnapping, beating girlfriend kind of thing in Washington.
That's a crime.
I've got attempted murder there in Custer, and I've got a bunch of pointing, possession of farm up felon, that's another case. And then I've got one tracking case, so.
What are you gonna do?
Like I tell people, nothing seems big after a 5-day murder trial, so
No, exactly.
nothing seems big at all.
Nope.
Like, 2-day trial, put that baby
That's
on.
easy. Yeah. Well, I'm hoping the one we have left starts next Wednesday, hopefully.
Gina told me she thought she was pleading that out tomorrow.
I thought so too, so I'm hoping. I've got my jury on hold, so. It's kind of silly.
Ms. Norwood, Ms. Norwood? I went and filed an open records request for, Angela Marcy's, oath of office. And I also filed open records requests for Gina Webb's. And the Secretary of State came back and said that Gina Webb's is not on file. Is that accurate? Do they have the oath of office somewhere else for Gina Webb?
I'm not sure, I don't hold those records.
Okay. I just thought it was odd that they wouldn't have her oath of office.
I'm not sure.
Okay. Do you need to see that letter?
I do not.
Okay. Is that Miss Sullivan? Miss Sullivan?
Yep, that's me.
Hey, and Miss Redmond? Hi.
Where's them?
Hi, I'm Roman. Wortham.
Where's them? Yeah.
Well, I don't know if it's in person, but because we know it's pretty ambiguous term there.
Not correct.
So are you still doing the cv-2025-00063 case?
Yes, withdrawn.
Really? So, Ms. Jones took your spot, is that correct? Okay. And did you withdraw for that one as well?
I did not.
Okay. Did you receive my, I filed some stuff in that appeal. Did you receive those things?
I don't know.
Okay.
We've got so many filings to do.
Okay.
Yeah, did you see that?
Take pictures. Oh, yeah. Oh, yeah. That's today. Oh.
Ms. Sullivan, did you receive my March 12th filing?
Yes, I did.
Yes, I sent it certified mail, okay.
Yes.
Did you see Exhibit E in that filing by any chance?
I do have it with me. Exhibit E?
Yes. For the 12th.
Yeah.
But they're coming back tomorrow, so, I don't have it.
Okay.
Yeah, you could tell that, you could read the frustration through it.
Came from Christie.
I only have exhibit.
The 12th of the March 12th, he should have just come in.
have it on.
I got you.
All rise.
Is it okay if I stand, Judge? Thank you, Judge.
We have case number cv-2025-00063. Style of it actually, this is Roman,
Vladimirovich,
Sure.
Improper noun. Yes, Judge.
Versus, Dirickson, and others. Would you announce the appearances for the record?
First Assistant Attorney Ricky McPherson for Donna Howe.
W.R. Moon on behalf of Andy Artis, Allison Levine, and Kill State.
Lexi Norwood for Marcy Webb, defendant.
Reagan Worker on behalf of Lexi Norwood.
J.P. Sullivan on behalf of Judge Donna Dirickson, Your Honor.
Judge, I'm the plaintiff. I'm Roman Vladimirovich Serpic, sui juris in pro per. And my name is in proper noun and not in all caps. I'm here in de jure at common law capacity and not in pro se. And I'm looking to testify on the record. Judge, before I proceed, I'd like to swear in and testify to the evidence here today, so I don't just argue with the defendants in the court. I'm looking to just swear in so the court holds me under penalty of perjury for everything I'm about to enter into the record today. Would the court have an issue with that?
Well, I would just want, as a preliminary matter, I was just trying to figure out for sure which motions we were.
Well, Judge,
Okay, everybody's not gonna get caught at the same time.
Judge, may I?
One at a time.
One at a time, Judge. As you know, yesterday there was an in-camera chambers hearing that was requested for your recusal, and that issue has.
Just starting with that.
Yes, Judge. So,
What would counsel's position be on that?
well, Judge,
Do I need to go and address, let him do that first?
absolutely, counsel, that's the rule.
Judge, unfortunately, I think you do need to address that. The part about it, though, is if you look at the record, Mr. Serpic has
Objection, I'm not Mr. Serpic.
One at a time.
Repeated requests for recusal over and over. In fact, since our motion to dismiss was granted, he's filed 3 motions for recusal. This is a blatant and pattern that he exhibits, whether it's in his criminal case, his federal case, or any of the many state court cases that he has filed. He uses this merely as a method to gum up the judicial process.
Objection, Judge, there's reasonable cause. There's only one other recusal request that's been filed in this case since the last one. It's yesterday, Judge. the defendant cannot come up with in the record where there's 3 requests for your recusal, Judge. There's been the one that's already been decided and denied, and then there's this one from yesterday. According to the rules, needs to be addressed first. If the issue with this one as well, Judge, on February 26th, there was a move by the plaintiff filed for an Eleazar to take over the court clerk, which is the defendant, Donna Howell's position, due to the fact that the defendant controls the record, which appears to be defendant Donna Howell manipulates the record to her will, and I have evidence of that in the record itself, where she manipulated 2 documents that appear in the OSCN that were specifically filed against her, and this has actually been happening in other cases where I've documented it, that defendant Donna Howell controls the record, which in this scenario, the issue is 18 days ago we filed this motion, not one defendant filed an objection, a response, and we even filed a notice today that plaintiff omnibus judicial notice of confession that was filed today shows all the, throughout the case, just a summary of all the motions that were deemed confessed that were not responded to by the parties, except there was a couple that was responded specifically by defendants Levine, Kyle, and Artis. Outside of those 3 defendants, the rest have not objected to a single motion, including the 26th February motion to appoint an Eleazar to replace defendant Donna Howell's issue, including what happened this morning. There was a filing missing from the record. It took me 5 days of arguing with the Beckham County Clerk's office to get this one filing into the record that was substantial in the case. And I have the printout from this morning showing that the record wasn't there. It's only after hours of back and forth communication with the Beckham County Clerk's office this morning that we were finally able to place the March 12th filing into the record and another filing into another case record. Judge, because all parties did confess by their silence, it's almost the court's duty to appoint a Eleazar in this scenario, or it would show that the court is an actual bias. Following the rules of the court, plaintiff procedurally did everything correct. For this to go down, the issue is it is prejudicial that defendants get their motions filed, and the plaintiff has to argue with the Beckham County defending clerk to get his documents in, and that's not the energy the plaintiff wants to spend. The plaintiff does have many cases that are in the state, the appeals, the federal court, the 10th Circuit Court, and the United States Supreme Court, where the defendants that are sitting next to me are actually also in the United States Supreme Court, which is due for a conference in 3 days from now regarding the defendant's hearing in that case, which Lexi Norwood represents Marcy and Webb and the parties, including the AG's office, which was Exhibit E in the March 12th filing. That is probably what plaintiff presumes the defendants did not want the judge to see, because it shows that there's absolutely no reason for negligence in the lower courts when these same defendant attorneys are prestigious and pristine in their filings and very accurate in their filings in the higher courts, but very sloppy in the lower courts. And plaintiff believes it's to doctor, manipulate, and distort the record from what it actually is. Judge, the first thing has to be settled is this request for chambers hearing, because if you don't rule according to the law, Judge, plaintiff will have no other venue but to file a motion right now to disqualify the judge in this case for actual bias. Defendants did not respond. A single defendant did not respond to the Eleazar motion. It's confessed. It's only for the court to rule in favor of that motion. It was an emergency motion, and it was filed 18 days ago as an emergency due to the issue that was happening at that time with the filings. Attorney's time, it's precious, okay? These are by the hour attorneys, and plaintiff's time is precious. Plaintiff should not have to chase around the records that are not in the record and then hold the county clerk / defendant accountable. It's not the job of the plaintiff to do so. And I believe, since since everyone already agrees by their silence that the motion is granted, and we appoint Eleazar to handle this case for the defendant and Beckham County Court Clerk. This is a very sensitive case. This has been referenced to the U.S. Supreme Court in the Certiorari issue that's up for the 9 justices in 3 days from now, where this case has been listed in the writ of certiorari in the United States Supreme Court. So that if they do grant certiorari, Judge, they are going to look back at all these proceedings, and it's Exhibit E in your March 12th filing, Judge. It's Exhibit E. It shows clearly that the defendants are the same defendants that are sitting next to me. Judge Whedon in the writ of certiorari is exactly who defendant and attorney Norwood represents in the writ of certiorari case. So the defendant's very well aware of what's happening in that case. And Judge, I want to just judicial notice for the record that the same state defendants did not respond to the United States Supreme Court when they asked for a response from the defendants. It should show you everything you need to see regarding this case about identity, which is the number one question, the sovereign citizen labeling instead of actually reading what the plaintiff is presenting, and access to the courts are the 3 devastating questions before the 9 justices in 3 days. And it just shows that this whole frivolous thing, this whole sovereign citizen thing is just an abuse by the defendants of the plaintiff. The 9 justices believe the case is important enough to bring it before a vote here in 3 days, and I believe it should be just as important for the court and the defendants in this manner. It's the United States Supreme Court, Roman v. Serpic versus former Judge Whedon, which is case 25-6625, which defendant Lexi Norwood represents that case, where Marcy, defendant Marcy, is also up in that case, including the state of Oklahoma, and the former Judge Whedon, including the officers that she represents in the federal courts, are all in that case, which the defendant did not respond to the United States Supreme Court, where the same issues that are presented here, Judge, were presented to the United States Supreme Court. And the respondents here did not respond there. So it just should show you everything you need to see. The Supreme Court got the 15.8 non-response notice, which after that notice, they proceeded to conference, which is, like I said, in 3 days. If you read through that case, it's devastating. It's all related to the criminal case, CM-2331. It's all related to how they attempted to charge the company, Roman Serpic, which is not my legal name. And when they realized the DA got caught in a fraud, these defendants and attorneys came together and created this all names are the same argument, which is another problem because the plaintiff has documented clearly that under 18 Oklahoma statute section 1141, the Secretary of State cannot make a business into that is somebody's real name. So if Roman Serpic was my real name, it'd be impossible for the Secretary of State to create a business called Roman Serpic. That's another where their argument fails. Another, Judge, is what I presented today in today's admission conference motion. defendants agree by their silence, again, to the scope of what's happening here, Judge. I believe the first things first, we handle this Rule 15 because if the court's going to be unfair to the plaintiff again, the plaintiff would have to file this motion to recuse the judge, which I'm going to ask to stay off proceedings until the Honorable John Parsley, which is the Chief Judge, looks into this matter. However, plaintiff does want to proceed with the February 18, 2026 move to establish procedural sequence for today's hearing, which the only party that objected to that sequence of events for today is defendant Levine, Artis, and Kyle. Outside of that, none of the other defendants to this date objected to that, except for they objected about 2-3 months late, which is defendant and attorney Norwood. However,
Before you proceed,
yes,
are there matters you want to address in camera?
yes, Judge.
We usually, I have always done that in chamber.
That is the accurate proceeding, unless you want it on the record. We can do that in chambers, or if you like.
Does counsel object if I go ahead and go off the record for that, or you think I need to?
No objection, to be honest.
No, that's what Rule 15 says.
No, yeah, no objection here. I think I'd just like to clarify for the record that his stated reason for recusal in this matter is based upon your ruling on his motion filed February 26, 2026, which you have not issued a ruling on yet. And it is, if you do not rule in his favor, at least that is what he has stated here in court on the record, that that is the reason for recusal.
Objection, Judge. If you look at the actual.
Let's go on, since there's no hearing, no objection, I'm
Okay.
going to come in chambers.
Yes, Judge.
Give me whatever reason you have.
Am I allowed? Can I bring these real quick? These documents?
Well, I don't want you to make the whole argument.
I got
you. You can bring whatever.
Yes, Judge. Okay.
Are we off the record, Your Honor?
Yes. Well, as soon as we finish, we'll go back to it.
Took us a little turn, you can't. Yeah. I apologize. Do you want me to?
Does he have to do something in the Supreme Court? I can look for it, I can't find it.
It's filed and there's like that initial, where you can respond if you want to.
But you don't have to.
But you don't have to. It's not coordinated. And so we're waiting for that, you know, the
No,
court.
the last And this is the criminal case?
No, this is a civil case against Judge Paul that we.
Yeah, I mean, they're not gonna get on the computer the day you file it.
Well, usually we do, but I've had.
He needs to try Washita County, cause it ain't happening for a week.
And there's.
Maybe a month.
I'm talking about one, there's no statute that says I have to have it on. Usually most are pretty on top of it.
Yeah, well, we're, trust me, places are not on top of it.
The second one, like,
Condition dismissed, they want to consider a labor matter. The appeal is really the first civil suit you brought before. And is that right, because I just looked it up, I couldn't find anything on 25-665.
I can send it to you. Cause I looked at it too, and I was like, and our shit in general is like, if they're like, I don't know.
Let's go back to July.
Yeah.
Then that crap afterwards, maybe it's important, and maybe not.
You don't follow the law, according to that.
Yeah. I mean.
I think that's
Be forced to kick you out.
Wait a minute, I'm pretty sure I heard that, let's get it on.
I know, that's right.
I think, what was it, time before last,
He went on for like 45, 50 minutes, just ever. Yeah. That's what he did. He's way nicer than most people. Most kids would be like, 3 points, give me 3 points at Beckham.
Why you
give it shit about what? Give me 3, and let's move on.
You know that this morning you have to beg every opportunity you're like,
Yeah.
yes.
He's one of
Like,
that.
where is the when she walks with you, and that was it, he's like, we confront us, it's a video.
It's my whole office. My whole office, not just me.
Right? Yeah. Ain't that one that addresses you guys?
Well, the one that kind of responded that February 24th, like, he just got a 3 days.
In Washington, violence is frivolous. That's the one I like the best. Yeah, I think you are word not to. You are not violating what shit. No, hey, this word where they dictate my judgment.
Ours.
That's the one I don't like.
That's what I was
This is the better order.
talking.
Where it says, stop this shit. Yeah.
Is that the one from the Supreme Court, the last one, when they said, I, we noticed you filed this the day after?
No, I mean, I think like we were, I don't mind.
The intention to disrupt or delay the court proceedings.
Yeah, stop filing crap. That's basically what they said. Stop it.
That's never gonna happen.
No, no, no violence.
Yeah.
I was a PD for a long time, and I just wish I had thought to say, well, judge, that's not my client's name, so it's all void. That wouldn't you have been intimidated by me?
Let it go.
Could have won every case.
I don't know. I believe I didn't think of it.
Not Roman circuit. Roman circuit is not real name. You're just standing right there.
We do have, and you should know that. They probably make it 27 years. Absolutely.
Funny when he's like, well, I mean, here in person, but we all know that's complicated. And you're like, no,
Not for us. I think what she said was not for us. Like, we're looking around, we all know it. Yeah. That's complicated for us.
That is like a philosophical question. Like, are we any of
How many guys
us?
are
I guess I
working
just
with
assumed it was us. I
this?
should have said it was me.
This is why I'm not playing games, either you did divorce or you're not. Are you Roman circuit or are you not Roman circuit? Usually I am. Then I'll get the divorce.
Really? That transcript is like.
Probably, yeah.
Deemed error, confess.
I ain't getting a divorce, or we're not getting a divorce. Yeah.
The wife. She wanted to work from all of them.
Yeah. All 3 of them.
He said last time I was here, this whole thing.
He did say that.
That's a good reason.
Yeah.
I would grant it.
It has consumed all of our lives.
I mean, the amount of time he probably has to spend making up these filings.
Allison, who's being sued, who you have not met, along with me, she, at Halloween time, found a shirt that says, it's like a lawyer's worst nightmare, and it says sovereign citizen. For a costume.
But he's not. I never remember
He's an Oklahoma national, sorry.
No matter how many things we ran over with sovereign.
They didn't have an Oklahoma national t-shirt, they just had the sovereign citizen t-shirt. But when we get attorney's fees, WR, I want it to be paid in gold bullion.
Gold or silver, because that's the only legal tender.
That's all I want. I don't want any
Federal notes. I want gold and silver. preferably doubloons.
That's all I'm saying. This could literally be an hour.
I have the transcript from July 29th, and I was just reading through it, I'm only had 17 pages with him.
Yeah, he rambled a lot that day.
Did it make sense? Did it make it?
Oh, it made no sense. Except when you said, and I know I'm gonna be a defendant on the next one.
Yeah.
Yeah.
I am actually shocked that I have not been.
She gave me my first real hockey. I feel very.
The first one?
The very first real, well, I got a notice that someone had like put my name, but I had never represented, like it's someone I didn't know, and so they were like, they were like, this came in, but whatever, but this one didn't. So that's the name I know. I had to wait until the fourth to act it.
So I got my first license plate, my second year out. Man, I've been out here a long time.
Yeah, I was in the DA's office when I got my first
No, actually, I
one.
started out as a defense lawyer.
Oh, really? I was like,
Defense, we did divorces, probate, we defended American States Insurance.
oh,
We were their counsel for any of their litigation, so we did a lot of insurance defense. Did a lot of deposed, wrote a lot of letters, work calls when you get paid. You get a letter back to,
Yeah.
I don't want to pay you. I mean, basically, what it's come down to, it's how long can you drag it out?
Yeah. How desperate can we make it?
Yeah, exactly, right? It's hard to down, they're ready to settle. And, yeah, I did that 3 years. Then I said, oh, let's go try this out. I don't have to take this one, except on my civil stuff. Well, my forfeiture is my county forfeiture.
Yeah.
My county business.
It was like, cause I was in the DA's office. And, during surgery, so, November during a deposition. But then it's like, oh, this is easier than a prelim.
Right. It's like, let's just ask a question.
Yeah.
Right? I mean, I still do all the civil for 5, 10.
Road date.
Like, I mean, get amazed how many contracts counties have. With, jail phones, jail commissaries, and road work. Now we've got windmills. You gotta have contracts with all those windmills because they tear the shit out of your roads. You gotta have contracts to say they're gonna fix them when they do.
Why do we have to wait for him to, so he's gonna deny his motion to refuse, and then he's gonna have the right to say yes to the refuse.
I think you have to file a request.
And does he have to wait for it all over again?
There's some continue. That's the way I read it. The judge can continue, but you only file a request. Well, as long as the judge doesn't recess.
Yeah.
After he says no. You give him time to run file. So, I mean, if you recess, he'll run over and file.
Yeah.
So we need to make sure he doesn't recess. He'll let us get our orders signed. Let's do our arguments and get our orders signed, and then he go file. And then we're in the same.
Yeah, but then we start, well, I was gonna say, then we go up again, and they're gonna say, yeah, that was a valid reason not to refuse, or there's no reason to refuse, and it's just this, like, cycle. Yeah, he'll file a motion to vacate.
What did the Supreme Court say in that order?
This one, this is a lovely one.
Yeah.
This is the one I like the best.
Yeah, I like that one.
Well, Jody did.
Yeah, the secret in the case petition noted that he intention to disrupt delay for proceedings.
I mean, he literally said it, that if you don't rule my way, I'm gonna file a motion to refuse. By the way, if you don't rule my way and appoint an Elizor for pursuant to a statute that says the sheriff may break open a building after he has been refused entrance.
Is that what he said?
That's the authority, yeah.
Well, I had never heard of that, I was like, I'm not gonna respond to that.
It's absolute nonsense.
Does that statute say anything to do?
There's a discovery master, but I never heard of such a thing.
I wouldn't even tell me what a definition of a license. What is one of that? He won't be able to tell me.
I looked it up.
Do you know what it is? An Eliza?
It's like when you get someone else appointed to do something for you.
Like a special
But I had to look it up.
Well, you need to pick a better statute. You need to get AI to do a better job of finding statutes.
Yeah.
AI will make it up.
Yeah, I read all the time. Oh, yeah.
Tackle every case.
You know, you can
Here.
run through the website.
Yeah, they'll do like fake citations.
Fake citations show up every.
Yeah.
You're just like,
And
only if you look at it. I mean.
We're required to call them out to find them.
Call them out. Yeah. This is fake, this isn't real, cite something that's not actually there.
there's definitely more with those those, and like you can tell that there are certain things where you can tell that they copied and pasted, and then you run it through West Chat, and like, it absolutely doesn't exist if it's not there for that population at all. I don't know. And I'm, AI uses a lot of water, I'm very anti-AI. I watch Terminator, okay? I don't like Skynet. I don't.
No, I saw this like explanation once of how sovereign citizen people think, and they have like a fundamentally poor understanding of the legal system, and they think it's like if you say the magic word, it's in the right order, then the judge has to do what you say.
Yeah.
And I mean, I always think of that when he's like, I'm not pro se, I'm pro sui juris, blah 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 blah. And it's like, buddy, there are no magic words. I mean,
Please and thank you.
yeah, those are the only magic words.
Yes, but, yes, but.
But it doesn't
Now,
matter.
are
Like,
you
he's
listening?
been told over and over in meetings that there's no good. Are you listening? There's whatever. Yeah.
I'm changing my,
Maybe a little bit louder.
I'll have all these injuries because I care about those ones that are
Sure, yeah.
that, I mean, recognize it's important to you, and I will offer you that respect. But the law, and when I'm talking to the judge, it's the same, it's the rules, it's the law.
Yeah.
And no, I have not committed an ethical violation by calling it that. That's just how it goes.
Yeah.
I feel all an individual.
It's just hard to follow. I mean, when you follow these things, I mean, you try to read it, I don't know what it's correct.
Yeah, exactly. And also that your legal mind is sophisticated.
Yeah.
Even though I'm not a great mark.
It's like the whole point of physical research is to make sure where, like, you sent it or you tried and they got it. It's like, you refusing them your entry that people got for this because like you got it. That's what the point about it is. Like,
Now you don't get to read it.
Like prison post conviction, you read those and you go, I go to the other. Here's what I'm gonna guess, these things are not good. You decide if I guess right.
I don't miss VCRs, yeah, I did.
Read them and you're like, I don't know what the problem is.
they have areas of legislature came in.
Oh, there's statute of limitations on them?
Yeah.
Oh, yeah, lovely, love that.
Well, as a court PD, I'm like, I worry about like discovery of issues way, but like there are carved out exceptions for
It's
that.
1 year from when you reasonably prove the person was found to err. And so you can make a good argument, or you didn't find it, and you can argue it, otherwise, go home, leave it alone. And if you've been in prison in the last 10 years, that's a lot. You've been in prison for a lot of cases. So, you know, and they They fixed everything. My attorney had these documents, and so he was saying that he didn't have them.
That's not how it works.
Yeah. No, yeah, no, the legislature did really help on the question. Oh,
And he also did a lot of, because I know he represents judges, and I gave him a lot of states on the commission and they act, which is kind of open up, but like, a lot of people who they've exhausted all their states and habeas and are trying to bring collateral back to the treaty, and sometimes they'll do it just like, it's actually been created, but of course that's not how this works. You don't get to exhaust all of your criminal appeals and then have a civil remedy and say that or that your rights are violated. The issue has been dealt with. But.
right. Well, I got nothing.
I would be the world's worst. I was telling them, I was like, I can't go to Nickel after I don't have a job. I don't want to be here. I can't do solitary. I can't do this. Not see my family. Oh,
Yeah, you'd be writing all kinds of.
Oh, I would love, because I used to do appeals, and it's like, I love doing that stuff, but.
And you're like, you're protected. You're
Yeah, I was like, you're gonna be real.
Maybe
You'll get more money than this.
commissary crap that you can even possibly do.
Maybe they'll pay me more.
But that's a quick.
Yeah, we got drones now, and used to be the t-shirt launchers, stuff shit over.
I remember that a few years ago, I was on the county, I don't know if they did shoots, but they had a little barbecue and they filmed it, in Oklahoma County Jail. I was like, listen, I'm not saying it's like safety above everything, but whatever. Yeah, they have a little fire there, too. I think, I don't know if it was on TikTok, but I just remember, because I don't have TikTok, but I remember seeing the video of it. Like, get away with it. Yeah. It was like, how do you have a fire in the middle of the, like, well, I mean, I know. So,
They live in that vape in Oklahoma County Jail.
I don't think so. I don't think so. I think so.
I said lots of counties do.
They make money on it.
Oh,
Yeah,
I'm
and you can
sure.
break them, and you can start a fire with them, the battery, blow them off.
That's how I started my car.
Yeah, it's already happened in Tulsa County. What do you mean that couldn't happen? Of course it can happen.
I don't know about Oklahoma County Friday, at the Oklahoma County Court clerk's office, and she took us on a tour of the remodel.
I was like, didn't they move? How is the new area?
Oh, it's beautiful. No, it's on the fifth floor.
Oh, cool.
It is so nice. And Rick's office actually, all right.
Well, at this point, we'll go back on the record. The plaintiff, Mr. Serpic is.
Objection. I'm not Mr. Serpic, that's really ambiguous. Can it just be plaintiff or Roman?
Okay, plaintiff.
Thank you.
He's asked me to recuse, and I've denied his request in camera, and I understand you're gonna follow.
Yeah, so,
You can't talk at the same time.
I apologize.
No, he's talking, so he's listening.
Yes, ma'am.
You wanna go ahead and follow?
Yes, so I'm gonna ask the court, I have a formal move to recuse on disqualification, notice of mandatory stay. I'd like to file immediately and stay these proceedings until this motion gets decided.
Ted, we're gonna ask not to recess this hearing. We have all traveled to be before this hearing. Mr. Serpic is once again attempting to intentionally disrupt or delay a lower court proceeding, which is what the court found on the last one. And that's exactly what he's doing again. This statute that he cites has absolutely nothing to do with anything that he says it does. It has to do with the sheriff breaking and entering into a building to get stuff. It doesn't have anything to do with the appointment of Ellisor. His court, because once you overrule his request, you may proceed until he files that motion.
Which I have right here in my
It
hand.
is appropriate for us to at least get orders from the July 29th, 2025 hearing where Donna Howe that case was dismissed against her, signed prior to that filing, because all he's trying to do is drag this out again. And if you recess, we won't get that done. We've got to deal with it in order. We still have the rulings from the July 29th, 25 hearing involving Donna Howe, involving the DA, involving, I believe, the judge, which those, because they didn't have with them that day, got sent back. Those are the first thing in line to be dealt with on cv-2025-00063. And I'm going to ask the court to deal with those before you take a break, before he has an opportunity to once again intentionally delay this court proceeding.
Judge, objection, because if this is true, he would have put it on one piece of paper that he was objecting to the 26th Eleazar motion. You got prominent attorneys, Judge. They all have access to high-quality printers and time. They could have put a 5-minute notice of objection within the last 18 days. Judge, that's the rule. They hold me to the rules. They should be following the same rules. I mean, how do they get to play certain rules for them and certain rules for me? Judge, they had time to object, if at least one even objected. Okay, but the fact that this attorney for Donna Howe is arguing that I'm wasting the time, we could have prevented all of this by all these defendants filing the objection, Judge. These are not pro se litigants, Judge. These are professionals.
Judge, I'm not wasting anybody's time. This court made a ruling back on July 29th of 2025 that Donna Howe's case, the case against her, was dismissed. We didn't get it signed until the 4th, because we didn't have it with us until the 4th of August. The court, he went up on his recusal because it got signed after he filed his notice of recusal. And so they vacated it. It didn't vacate your ruling. They just vacated the document. So if we're going to deal with this in order, which is how we have to deal with cases, is
I'm
we
just trying to
start.
be careful, because the Supreme Court did vacate the order, the journal entry.
They only vacated the ones after he filed it.
Judge, only the 4th and 8th.
I'm talking.
I apologize. But only the 4th and 8th.
I didn't hear what you said.
Judge, I will. As to the other defendants, they had their journal entry there. He asked you to recuse that day, if the court will recall. He asked you to recuse on the 29th, and because they had their document ready to be signed, and he had not filed anything, asking to go to the district judge, they didn't overturn your dismissal of the other defendants. They only overturned the dismissal of the defendants who got their documents signed after he filed his request to have the district judge review it, the presiding judge review it. So, no, they didn't overturn them. I mean, they just didn't overturn that. They only overturned part.
If I could, Your Honor, Ms. Norwood, also a defendant in this case, but I represent Martine Webb. The Oklahoma Supreme Court, in that order vacating our 2 journal entries, they also said, until the remaining defendants are dismissed through an order memorializing the July 29, 2025 court minutes, appellant's appeal remains premature. So all we need time are our orders from that July 29, 2025 hearing, so that Mr. Serpic can
Objection.
appeal.
I'm not Mr. Serpic. Judge,